It's now 1 minute past 1. So welcome on behalf of Bristol Law Society for our 2022 insurance law update. Delighted to be joined by Professor Rob Merkin, now KC, from the University of Reading. I'm Leon Smith, a council member for Bristol Law Society and a solicitor at DAC Beechcroft in Bristol, with a particular interest in indemnity insurance and litigation, and I'll be fielding any tricky questions from our virtual floor this afternoon. We are delighted to see so many local, national and international law firms, brokers and insurers represented with us today. I've been asked to ask you all to make sure that you're showing your full name so that Bristol Law Society can see that you've joined the call and so that we can circulate copies of the slides and case notes following this webinar. If you haven't done so already, then please make sure that you sign up for our emails and newsletter online at www.bristollawsociety.com. Today, our guest speaker, Professor Merkin, specialises in the areas of insurance, reinsurance and arbitration, and is published regularly in each of these areas, as well as editing journals such as the Lloyd's Law Reports and Insurance Law Monthly. He's also the Honorary Life President of the International Association of Insurance Law. We're delighted to welcome him back today for Bristol Law Society. He'll be taking us through a number of recent cases, including the latest post-COVID-19 decisions, and in particular, the various cases on business interruption insurance. There will be time at the end for questions, so please do make use of the Q&A box at the bottom of the screen. And I've been asked to ask you please to ensure you use the Q&A and not the general chat box so that we can direct the questions appropriately. Please also note that this session will be recorded, so don't ask any questions or type anything into the boxes which you would not be happy to see later on our excellent YouTube channel, where you'll also find recordings of this and previous webinars. Thank you, Rob.
Thanks, Leo. In any one year, it's very difficult to know what we're going to get in the way of insurance cases. All we know is that we're going to get some. And this year we've had a bumper crop, all sorts of stuff, motor, marine, property, liability, and of course, business interruption. So what I'm going to do today is try and weave some general principles out of the vast array of cases that we've had. And I want to start with aggregation. Now, those of you who are steeped in the industry will know all about aggregation. Those who are relatively new may not appreciate just how important aggregation is. But I've been working in this area for, I don't know, since Victoria died. And aggregation is the one issue that keeps coming back. It's a key issue. And it's about two things. It's about how many excesses the insured has to bear. And it's about how many limits of indemnity the insured is able to recover. And in any one case, the argument may be different depending upon the sums at stake. Normally, an insured is going to want as many limits of indemnity as possible so you can recover several times the policy limits. Insurers are going to want as many deductibles as possible because each deductible may be quite large, so you may get no recovery. So it's not possible to have a contra proferentum principle in aggregation because it works differently depending upon what the figures are, and it may be in advantage for the insurers or the insured depending upon the facts. But what I want to do is talk about general principles, and then we'll look at some other cases. The general principles you can see. There are basically two types of aggregating provisions: event occurrence on the one hand, and cause, originating cause, source on the other. An event or an occurrence is something that happens at a particular time, particular place, and a particular way. And a cause, or originating cause, or a source, is the reason. And it can be summarized as saying that an event or occurrence is the what, a cause is the why. And when you have an underlying cause, that's a much wider aggregating principle. So that's the basic distinction. And then we have, as you can see from the note, an increasing use of what are called series clauses, whereby a series of losses arising from events or occurrences or causes are added together and treated as one. The word series is inherently ambiguous. It can mean one of three things. It can mean a sequence of entirely different things, which can be aggregated, or it can mean a sequence of things of a similar type, or it can mean a sequence of things that are connected to each other, depending upon the context. And the wording you normally see is a series of related events. So you then get the question, when are events related? Is the relationship between the type of event, or is it relation by cause? So those are the questions that you get arising under insurance contracts. But it might make more sense to look at some of the cases, and then you can see how these points actually arise. And let me start with Allianz and Rawson, which is a New South Wales decision. There are a fair few Australian and New Zealand cases dotted around in here, but they have the same principles at common law, and so they're quite useful illustrations. Here you can see that there's a $10,000 deductible any one event. So the insurers are immediately going to be wanting as many events as possible, and the insurer is going to be wanting as few events as possible. And you have 122 houses in development, each with tiled roofs. There's a hailstorm. Each roof is damaged. Now, if there's one event, the assured only has to pay or lose 10,000. If there are 122 events, the assured loses 10,000 on every one, which means the chances of recovering anything are pretty limited. Now, as it turned out, the way the policy had been placed, it was a declaration policy, so each building was declared separately. So there was, in fact, a deductible applicable to each. So the assured lost out quite heavily. Although the court did say that if there had only been one insurance, there would have been one event, which was the hailstorm. And you can see that a hailstorm is something that happens at a particular time, particular place, in a particular way, and you can add the losses together. But if we then turn to this jurisdiction, two very important Court of Appeal decisions, Spire and Baines, Dixon and Coles. Spire is liability capped at one source or originating cause. This is a consultant breast surgeon who has two particular proclivities. One is to carry out his duties negligently by leaving behind infected tissue. The other is to carry out other procedures fraudulently, performing breast surgery that didn't need to be done, telling people they were ill when they weren't, and claiming money on that basis. How many sources or originating causes are there? Now, there are earlier cases involving professional indemnity policies where the courts have taken the view that a person is an originating cause or a source. A person's propensity to be negligent, to use the euphemism, a blind spot, if you like, is the cause, and each time is the cause. That's right. And each time the person is negligent, there's an event. So that's how the aggregation would work. In Spire, at first instance, the judge came to the view that although it was only one person, there were two separate sources. One was the negligent behaviour, one was the fraudulent behaviour, which meant that the assured could recover two limits of indemnity. That was reversed by the Court of Appeal and said, no, there's only one originating cause, and that is the individual. And you can see from the last line of the note, the cause was dishonesty, absence of informed consent, or disregard for patient's welfare. So the basic rule is that if one person is acting negligently in a variety of ways, and aggregation is by reference to the cause or source, there's only one cause or source. So you only recover once. You don't recover for each separate type of negligence or fraudulent conduct. Baines, Dixon, Coles and Gill is a series clause. And you can see the phrase series of related acts or omissions. So what is a series? What are related acts or omissions? This is sadly a partner in a firm of solicitors who's embezzling funds from various clients. The method is the same in each case. just taking money out of the accounts. The cover-up is the same in every case. And the question then arises, how many times can the insured recover under the policy? The question, the answer given by the court is that the word series simply refers to a sequence. So they have to be related to each other in some way. And what we had here was completely unrelated frauds. The only thing they had in common was that they were the same. They weren't connected to each other in any other way. So we know that the word related doesn't mean similar, it means connected. One leads to another. These were completely separate. Each of them could have been done separately. Therefore, the frauds were a series, but they weren't related to each other. And then we have the question of how all of this applies to COVID-19. And the test case from the Supreme Court, which is, gosh, nearly 2 years ago now, we know that the pandemic is the cause. So the underlying cause of all of the losses that come is the pandemic itself. One of the questions that's arisen in the reinsurance context, but not yet at the underlying insurance context, is whether the pandemic is a catastrophe. Now, it depends how you use the word catastrophe, but a catastrophe can be a cause, if you like. It can just be something that happens. It's the underlying reason. Or you could construe the word catastrophe as meaning catastrophic event. So once you've got the word event in there, you're not looking at the pandemic as a whole, you're looking at individual losses. And this is really important for the reinsurance context, because reinsurance treaties talk about aggregating losses from any one catastrophe. So you can see how important that's going to be at the reinsurance level. If there's one catastrophe, you add all the losses together. If each time there's a loss, there's a separate catastrophe, then you recover thousands of times. So what does the word catastrophe actually mean? Now, we don't have any reinsurance authority on this, but we do have a decision of the full court of the Federal Court of Australia, which assumes that the word catastrophe could include a pandemic. In other words, it's not a catastrophic event, it is a cause. On the facts of that particular case, the phrase was conflagration or other catastrophe. And the court took that to the word catastrophe to take its meaning from the word conflagration. In other words, you're looking at physical loss as opposed to an overarching event, so overarching cause. But for that phrase, conflagration or other, the court would have held that catastrophe includes a pandemic. So at the reinsurance level, we haven't seen any reinsurance cases yet, but they're out there, believe me. This is going to be a live issue. But the most recent batch of cases decided by Mr. Justice Butcher, Stonegate, various eateries and Greggs, which are about a month old now, I guess. Lots of issues in these cases, but one of them is the meaning of the phrase occurrence, because there is a recovery per occurrence. So how many occurrences were there in the pandemic? We know there's one cause, which is the pandemic itself, but how many occurrences are there? And there are lots of different possibilities that are discussed by the court. The outbreak in China, is that an occurrence? Well, the court said it could be an occurrence, but it's too remote from the losses that are occurring in England, so it doesn't qualify as an occurrence. Spread of disease in China is the same. What the court decided the occurrence was the decision of COBRA on the 16th of March 2020 to lock down. There's a single occurrence based upon that. And as you know, there were changes in the restrictions at various times. There was a second lockdown and a third lockdown and so on. The court has concluded that each of those decisions is the occurrence which aggregates the losses that the assured has suffered. So for every occurrence, the assured has a separate limit of indemnity, in effect. The assured's rather optimistic argument that each case of COVID was a separate occurrence was not accepted. And the court also looks at the question of the renewal or modification of restrictions, and basically says that if there's no substantial change in the restrictions, then there's no new occurrence. But if there are new restrictions, there's a separate occurrence. Now, we don't actually know from this case how many occurrences there actually were. This was simply a decision on principle, discussing this is the concept. There will have to be further hearings if the parties can't agree as to exactly which of the government interventions constituted an occurrence for aggregation purposes. So that's the main significance of these three cases. And the assureds did quite well because they're recovering more than once under their policies. Now, the next topic I want to jump to is subrogation, because again, we've had a rash of cases on this. And a question that keeps coming up in landlord and tenant, shipping, construction contexts is, what is the effect of A and B both being parties to the same policy, but B causing loss to A? The argument, well, the issue runs like this. Suppose you've got a landlord and tenant, and the landlord has insured the premises. The tenant negligently sets fire to the premises. The landlord's insurers pay the landlord and then exercise subrogation rights against the tenant. In what circumstances does the tenant have subrogation immunity from a claim of that sort? And the answer, very briefly, is it doesn't depend upon the policy. It depends upon the lease. The question is, does the lease give the tenant immunity from proceedings by the landlord? Because if the lease gives the tenant immunity from landlord proceedings, by definition, it gives immunity from subrogation proceedings, because insurers have no better rights than the landlord. So what we have to look at in determining whether someone is immune from subrogation proceedings is whether there is immunity as between the parties themselves. And I've given you a couple of situations. In the construction industry, landlord and tenant, as I said, shipping, it is very often the case that party A is required to take out a joint names policy naming party B. So landlord has to take out a policy naming the tenant. Now, don't be misled by the phrase joint names. Joint names does not mean it's a joint policy in that the parties' interests are indivisible. A joint names policy is actually a composite policy where the parties have different interests and different claims and different rights. But in essence, if there is an obligation to take out a policy by A, then you can see the consequences. B is immune from proceedings from any claim that by A that would have been covered by the insuring obligation. In other words, what A is saying is, don't worry, I'll insure, and by implication, I'll look to the insurers and not to you if there's a loss that you cause. That won't work for deliberate misconduct, by the way. If B deliberately sets fire to the premises, then that wouldn't be covered by the insuring obligation, because you're not giving immunity for fraud or deliberate conduct. You're giving immunity for negligence. So there's immunity for any claim by the main assured, landlord, ship owner, whatever it may be. It's irrelevant that B has its own insurance. It's often been argued, well, look, you've got your own insurance, therefore, by definition, there's no reason why we can't sue you. It's not relevant. If B happens to have their own policy, good luck to B. But it doesn't affect B's immunity from A. And most importantly, it's not necessary that B is responsible for the premiums. Very often it will say A will take out the policy and B will pay the premium. But it's not necessary for that to be the case. It just often is. So joint names is effectively giving immunity to party B. If there is no joint names obligation, but simply an obligation to insure. So if A says, I am obliged to insure on your behalf, you're not a party to the policy. What I'm doing is effectively saying to you, I'll take out the policy and I will look to the insurers and not to you if there's if there's a loss. So it doesn't really matter whether you have a joint names policy or simply an obligation to insure for the A to insure itself. Both of those will give immunity to the third party. And then we come to a completely separate issue, which is relevant to COVID, as you will see, which is that an insurer, by exercising subrogation rights, can recover from a third party if the third party has already paid the assured. Then the insurer's liability is diminished to that extent. And the reason for that is that insurance is an indemnity contract, and therefore any money that the assured gets to offset the loss is deducted from the insurance proceeds. The insurers are indemnifiers of last resort. That's the principle. So if we turn to some of the cases, you can see how this is working. Herculito and Gunver is a complicated shipping case, but basically the owners have agreed with the charterers to insure a vessel against war risks, and the charterers are required to pay the premium. And then the terms of the charter party, as ever, are incorporated into bills of lading with cargo owners. So you've got owners, charterers, and cargo owners in effect. The vessel is captured by pirates. The insurers of the vessel pay the ransom, and the owners then declare general average. In other words, they're seeking a contribution from all other interested parties to offset the loss that they've paid in by way of ransom. It's held by the court. They have no claim against the charterers because, as you can see, the charterers are paying the premium. They are effectively the beneficiaries of the insurance, and it would be crazy if the insurers could subrogate against them. But on the other hand, the cargo owners haven't paid the premium, even though the terms of the charter party are incorporated into the bills of lading. The insuring term simply doesn't work because the cargo owners are not the charterers and they haven't paid the premium. So there is a general average against them. That's the effect of Herculito and Gunver. But the most important point is really the first one, that if the owners agree to insure and the charterers say we'll pay the premium, there is by definition subrogation immunity. My view would be that even if the charterers hadn't agreed to pay the premium, you'd have got the same result. Because the charterers are not going to insure if the owners are insuring. Why should they? It's just a duplication. The AAI Vero case is simply making the point that if you are underinsured and there are recoveries from the third party, the underinsurance is paid off first. The insurers only get paid once uninsured losses are recovered. So if there's a shortfall in recovery from the third party, the insurers take the hit. It's a recover down. So that the initial sums go to the uninsured amount, then the anything left goes to the insured for the benefit of the insurers. Sompo and RSA raises a point that I've never come across before. It's in Singapore. Subrogation is stated by the Marine Insurance Act to apply to all rights and remedies. And the court in Sompo held that there's a subrogation not just to a claim against the third party, but also to a performance bond payable to the assured. And finally, Rugby Football Union and Clark Smith, which is to do with the redevelopment of Twickenham. Once again, a subrogation immunity case, head contractor saying that I'm going to insure existing structures. subcontractor causes loss, it's held by the court that there's no obligation upon the contractor to insure for the subcontractor other than for existing structures. So there's no immunity for damage caused by the subcontractor to other parts of the property. So what you have to do in every case is look at the contract between the two policyholders, or between the assured and the third party. Does that confer immunity? Is there an insuring obligation? Is there a co-insuring obligation? If there is, there's immunity. If there isn't, there is no immunity. So you don't look at the policy, you look at the relationship between the parties. Big question that has arisen in subrogation for COVID is the effect of furlough payments. My view right from day one of this was that anything that the policyholders have received from the state by way of furlough or by way of rent rebates and all these types of things have to be deducted from the insured sum, because those are insured losses. And if the insurers have to pay those sums in full, that means that the insured gets a benefit. They get their insured loss from the state and they get it again from the insurers. So I never thought there was any real doubt about this, that furlough payments have to be deducted. The Financial Conduct Authority thought to the contrary and issued a statement saying, we do not expect insurers to deduct anything by way of furlough payments. They simply pay the policyholder the full amount. This came up in Australia in the Marrickville case, one of two test cases in Australia, and the full court decided that the sums were not paid to the policyholder by way of insured loss. They were paid for financial hardship and therefore did not fall to be deducted. I have to say I think that was wrong, and I'm glad to say that I was vindicated by Christopher Butcher in Stonegate and Greggs when he held that furlough payments, business rate relief and other sums received by the assured are to be reduced, or to be deducted rather, from the sum insured, because otherwise the assured is making a profit. There's a very interesting analysis of the old cases in the judgment, and he basically says that unless it's paid sort of ex gratia to offset personal feelings or hardship, then you have to deduct it. I'll give you an example of what I mean by that. Suppose my daughter has a car accident and damages her car, and I say to her, oh look, here's £500, that make you feel better. The insurers could not deduct that sum from the insured amount under the policy, because it's nothing to do with the insured loss. It's simply a personal payment that I'm making. So unless you can classify a furlough payment as that, it has to be deducted. The Australian case was turning very much on the facts of the wording of the clause, but I don't think that the wording of the clause actually supported that view at all. So I think that Stonegate and Greggs have probably got it right. I want to say a few words about claims, because under the Insurance Act 2015, two things have happened. First one is that we now have an entirely standalone concept of utmost good faith. That under the old marine insurance legislation, before it was amended by the Insurance Act 2015, utmost good faith was effectively confined to pre-contract disclosure by both parties. Under the Insurance Act, it's divorced. So we now have presentation of the risk, which is to do with disclosure, presentation by both parties, and we have utmost good faith as a completely separate, standalone concept. But what the Act doesn't do is to tell you what the remedy is. And we know, we're pretty sure at least, that it's not an implied term. So there's no damages arising from a failure to act in good faith. It's simply a sort of standard of conduct. And In Australia, they've had an implied term of utmost good faith since 1984. And you look at the Australian cases, you just don't find any cases where even under an implied term, utmost good faith does very much other than simply say to the parties, you need to sort of act fairly. And I've just given you Diamond World Jewelers and Catlin as a lovely illustration of how utmost good faith makes a very different difference in practice. This was a case in which both parties were held to be in breach of the duty, but it didn't make any difference. So a really bizarre story, and I just thought it's one of those cases where if they're ever going to make a film of an insurance case, this is the one. It's a break-in at a jeweler's. The people that break in are just a bunch of kids who are apparently drugged up. They tell the staff to open the glass cases. The staff refuse, so the kids smash them. Manage to cut themselves and leave blood and DNA all over the place. They run out of the shop, leaving most of the stuff behind them. The assured phones up his broker, and the broker obviously was smoking something very interesting, because the broker said, well, the best thing you can do is clean up, and then we'll tell the insurers. So what the assured then did, following the broker's advice, was to repair all the broken glass, clean the place up. Anything that was in a broken cabinet was melted down, so that when the insurers come to inspect the premises, they're absolutely pristine. And the insurers say, well, we can't pay you unless you can produce records. And at that point, it becomes clear that the assured didn't keep records, and the insurers knew they didn't keep records. It was part of the disclosure process. So you've got the assured having basically covered up what had actually happened, and the insurers demanding proofs that they know don't exist. Both of those parties were held to be acting in bad faith in those circumstances. It didn't make any difference, because the assured was still able to recover for the loss that it could prove. Just a fascinating little example of how good faith works in practice. The other case is much more important, I think, and this is Quadra and XL. And this is the first case we have on late payment. The effect of the Insurance Act 2015, Section 13A, which was added by the Enterprise Act 2016, is to give an assured a claim in damages for any loss caused by late payment. This reverses the common law decision in Sprung and Royal, where the assured basically went out of business because the insurers refused to reinstate the premises, and therefore the business just collapsed. No damages, because the insurers were liable to pay damages on the date of the fire, and you can't be liable in damages for not paying damages. So what the Insurance Act has done is to reverse that principle and to say that there is a separate implied term that insurers will pay within a reasonable time. And if they don't, there's liability for extra damages. This is another Christopher Butcher decision. Excuse me. The court says that Section 13A is a two-step process. Step one, was there unreasonable delay? Step two, if there was, do the insurers have a defence because there were reasonable grounds for contesting liability or quantum? And the court says there was unreasonable delay in this case. Insurers should have paid earlier. But on the other hand, they did have reasonable grounds for contesting liability, and therefore no damages were payable. So it looks as though Section 13A is less useful than we thought it was. There's also a long discussion of insurable interest in this case as well, but I won't bore you with that. It's mainly for marine purposes. Property insurance. There's a reference you won't have seen very often, ADGMCFI. This is from Abu Dhabi. But the Abu Dhabi courts use English judges. This is Sir Andrew Smith sitting as a retired judge. So it's basically an English decision. These are all on Bailey as well. They're quite interesting decisions. This was a case of an aircraft that was damaged and repaired. Insurers have to pay for the repair costs, no argument about that. But what the assured also seeks to recover is accelerated depreciation. on the basis that something that's been repaired diminishes in value. Now, in tort, accelerated depreciation is ahead of recovery. If somebody damages your subject matter, you can get repair costs and you also get diminution in value. But you don't, according to the court in this case, get that under an insurance policy. An insurance policy which covers loss or damage only covers the repair costs. It does not cover the fact that the life of your property has been reduced, or that it's going to diminish in value because it's been repaired. The next three are all from New Zealand. Quite interesting little cases, I think. If you have a situation where the property is damaged and you carry on insuring it in future years, and then you do a deal, which maybe 3 or 4 years later, which fixes the original loss as a total loss, then you've paid premiums for no reason on the renewals. And the ECH and Vero, the court decides that you can recover those premiums from the insurers paid under mistake. Sneesby is another important earthquake. The earthquake has happened in 2010, 2011. We're still getting cases coming through a decade later, so that's the way these things go. But this was the effect of a full and final settlement, discharge of any claims known and unknown. That wording is now pretty standard. There was a case here called BCC and Ali about 20 years ago, which said that if you want to protect yourself against changes in the law, retroactive changes in the law, you need to put in known and unknown, otherwise the settlement won't work. So what you have here is a settlement based upon no recovery for builder's margin, contingency and other allowances under an insurance policy, settlement done on that basis. And then subsequently, the Supreme Court of New Zealand changes the law and said these things are recoverable. And as you know, the common law is declaratory. So when you reach a decision, it dates back to the year 1189. So as from the year 1189, these sums were recoverable. How does that affect the settlement? The answer, it doesn't, because the settlement is full and final, all claims known and unknown. That means that retroactive changes in the law don't affect the settlement. So it's really important to use that phraseology. And IAG Insure is a very recent decision. A motorhome was seized in a family dispute, and the issuer put in a claim for the motorhome, and the court took the view that it was lost. The word loss requires permanent deprivation in a non-marine policy, and the court was convinced that this was going to be permanent deprivation. I'll come back to those if I've got time. I want to just say a few words about liability insurance, because I guess this is one that is most important to everyone. A couple of years back, sorry, that should be 2020, Marex and Cervelagia, the Supreme Court basically said that you can't recover as a shareholder. So I'm just going to stop this for a second. Sorry, let's close that. Okay, the Supreme Court said that if you're a shareholder in a company and the company has an insurance claim, you as a shareholder don't have a claim as well. Sorry, a tort claim. You don't have a claim as well because you're recovering twice. And the question that arose in Adelaide, Pools and Westcourt is, how does that apply to an insurance claim? This was a case where assured's business is destroyed by fire. There is a claim against the insurers by the company, and the shareholder of the company also puts in a claim against the insurers saying, look, I've suffered loss as well. And the court's basic view is that you as a shareholder don't suffer additional loss. The only loss is suffered by the company itself. But you see, the case went back to a court for a second time. And on the second occasion, the insured was actually able to prove that had been additional loss, because what he'd done is he'd sold off assets in a sort of fire sale to fund loans to banks, or to repay loans to banks. And that was also a consequence of the fire. So the loss was not simply reflective loss, it was direct loss. Burnett and International Insurance of Hanover is a really important case on the word accident and the words deliberate act. Liability policies cover accidents and they exclude deliberate acts. This was a case of a nightclub or pub bouncer who was over enthusiastic in his approach to a particular customer and actually managed to kill him by kneeling on his throat, trying to restrain him. The policy covers accidents and excludes deliberate acts. Was this an accident? Well, says the court, you have to look at an accident from the point of view of the assured. The assured in this case is not the bouncer, it's the bouncer's employers. And as far as the bouncer's employers are concerned, they didn't authorize this. It was unexpected from their point of view, therefore there's an accident. Was it a deliberate act? Answer given by the court, no, because a deliberate act is one whose consequences are intended. And this bouncer did not intend to kill. Indeed, he was charged with murder and convicted only of manslaughter. Therefore, this was an accident and it was not a deliberate act. So the insurers were liable. You might take the view, perhaps with some justification, that the court is looking to provide compensation to the victim's family in this type of case. And they're using insurance as the means to do it. But nevertheless, that's the effect. And then we have three cases from Australia on the meaning of reasonable care clauses. You find reasonable care clauses in virtually every policy these days. And it's clear from the cases going right back to the 1950s in this jurisdiction that reasonable care means that you must not deliberately court the risk. It's recklessness. It's not merely negligence. If it was merely negligence, you'd never recover anything under the policy. So a reasonable care clause means you must not be reckless. And in both Lloyd's underwriters and Flanagan and Bernasconi, there was deliberate courting of the risk. In the Lloyd's underwriters case, it was a failure to listen to a warning by the scaffolding company that you mustn't have scaffolding near electric wires. They weren't listening properly. And in Flanagan and Bernasconi, this was a case where the owner of a swimming pool was told, don't leave it empty, because if you leave the pool empty and there's ground heave, your pool will crack. In both of those cases, warnings were disregarded and therefore the assured deliberately courted the risk. And I think what we learn from that is that if the assured is unaware of the risk, they can't be guilty of lack of reasonable care. It's only when you're aware of the risk and are told about it and you choose to ignore it that you deliberately court the risk. And Ritchie in Advanced Plumbing is a contrasting case where there was no failure to take reasonable care, but on the other hand, there was a relevant exclusion in the policy. And then finally, I'll just deal with the Tuggins case, which is a claim by solicitors for indemnity under a liability policy. And they sought to recover, in effect, the fees that they would have been, that they were paid. I think it's fairly clear, and you can see it from APD and Maximo, that a restitutionary claim does not give rise to a claim under a liability policy. And the reason for that is that if a claim is restitutionary, it's a claim for money that the assured shouldn't have had in the first place. So you can't argue that you suffered a loss if you're giving back something you should never have had in the first place. But what about fees? The claim in this particular case was carefully framed by the third party. It wasn't a claim for recovery of fees for not doing the work. It was a claim for damages. But the claim for damages was the amount of the fees. And the court decided, this is Justice Foxton, that that sort of claim is recoverable. You're not claiming for lost fees, you're claiming for damages. And that is a liability under the policy, and therefore there is recovery. I think it was a fairly extreme case because the amount of fees was massive. It was several millions. It was basically an introductory fee. But nevertheless, the principle holds good. So solicitors can recover lost fees under a liability policy as long as the fees are being claimed against them by the third party by way of damages. Lots more cases that I haven't got time to talk about, but I've got notes on all of these, and I did promise that I'd circulate the notes afterwards. So at that point, I probably need to stop talking and see if there are any questions.
Thank you very much indeed, Rob. We've had a few questions and comments that have come in on the Q&A. First one relating to your reference to ECH holdings. Someone wasn't quite sure if your commentary had contradicted the on-screen text regarding the decision, and perhaps you could please clarify.
Sorry, let me just go to it. So I can't find it. Yeah. Oh, sorry. Yes. Sorry. There were two aspects to this. First of all, were the premiums in principle recoverable? The answer was yes. Were they actually recoverable? No, because there was a settlement which covered the premiums as well. So the point I was making is that in principle, if you've suffered a total loss and don't realize it till afterwards, then you can recover your premiums. But in this particular case, the settlement applied to all sums in relation to the policy, and therefore that the premiums were excluded. My apologies.
Thank you very much, Rob. Another question going back to SPIRE and RSA. On the slide, I think you listed the cause as being dishonesty, absence of informed consent, and disregard for patient welfare. Clearly, the court felt that these all overlap quite considerably. One could, I suppose, forgive a layperson from thinking that that list actually sounds potentially like three separate, distinct causes.
Sorry, it is or. It's not and.
Or do you anticipate, therefore, that there might be changes in policy wordings, especially in consumer insurance policies, to try and make the likely interpretation a little clearer?
I'm not sure. Sorry, this is a quote from the judgment. I haven't paraphrased it. That's actually what the court said. I think the court is making the point that a person is a cause, and everything that person does is the same cause. Now, I suppose you could, if you've got an event-based aggregation principle, then of course that wouldn't apply. This is a source or originating cause-based wording. So if you simply say liability capped at X amount per event, then you would have probably as many events as there were negligent acts. So it depends upon what sort of aggregation wording you're using. But the cases are very clear that if you use the word cause, that's the person. If you use the word event, that's every negligent act that person carries out. So I don't think they're going to alter their wording. They might alter the nature of the aggregation, but they won't alter the wording itself.
Thank you. On a similar vein then, if circumstances similar to that case arose, but under a joint names policy, in that case, I suppose with a particular individual doctor having been held again to have been both negligent and or deliberately fraudulent, would that leave the individual on those facts immune from suit for negligence, but liable for fraud? And if so, and if insurers proceeded on that distinction, would that perhaps then be reflected back on their attempts to rely on the aggregation clause to say that they're one and the same thing?
Right. This was actually this was a case where the doctor wasn't insured. This was a case where the company was insured against liability for the acts or omissions of its employees. You can get cases where employees are co-insured under the policy. And indeed, on the handout, there are a couple of Australian cases to that effect, where the employee is separately insured as in its own right. The rule would be that the insurers would pay for one cause, but they would have a subrogation action to the extent that the losses were caused by fraud as opposed to negligence, if there was a co-insurance in that situation. So I don't think the aggregation provision would work.
Thank you. And then again, actually on the topic of subrogation, if B's subrogation immunity depends on the terms of the contract between
Yes.
A and B, we've been asked what happens if the contractual provision is unenforceable by virtue, for example, of the Unfair Contract Terms Act?
It's not an exclusion clause. It wouldn't be within the Act, I don't think. It's not actually saying we hold you in. For one thought, no, it wouldn't. It's the wrong way around. This is not the subcontractor saying, I want to exclude my liability to you. This is a case of the employer saying, I'm taking out a policy on your behalf, and thereby impliedly promising that I won't sue you. It's the wrong way around, if you like.
Thank you. I've been told we've got time for one more question, and also asked us to remind everyone next week's talk on the 29th of November is part of Islamophobia Awareness Month. So please sign up online or pass on details to any colleagues who might be interested. But otherwise for you, Rob, you mentioned Stonegate and MS Amlin and Greggs and Zurich.
Yes.
It seems that all of the parties involved in that case, or at the very least, the PR departments of the various barristers' chambers instructed, sent out press releases immediately afterwards, claiming it to be victory. Of course, there were quite a few arguments put to the court. You summarised the key ones, but not necessarily all of them.
Yeah.
On balance, in your view, Professor Merkin, who won, the insurers or the policyholders?
I think it was the score draw. The policyholders were desperate to prove there was more than one occurrence, because the insurers were saying there's one occurrence, which is the outbreak, and you can't recover. You recover once. So there's a sort of victory in the sense that you get more than one limit of indemnity because there are different occurrences at different times. There are also victories for the insurers win very clearly on the subrogation point. The insurers also win on a causation issue, which is if the policy terminates, are the original losses carried forward? Because basically, let's start again. The indemnity period is, let's say, a year, but the policy may terminate before the indemnity period has expired. So you've got losses in the indemnity period, but after the policy has expired. So you have to prove that those post-expiry losses are caused by something occurring in the policy period. And so what you have to do is to try and link the later losses back to the earlier losses, which the court said you couldn't do because there's no link between them at all. Now, again, it's set out on a slide. So to that extent, the insurers win on causation. So it's a score draw, but I think we need to see what the outcome of all of this is, because this is only setting a parameters for the disputes to carry on. It may be that what happens thereafter is that everything goes to arbitration. That we have every BI policy I've ever seen has an arbitration clause in it. And so it may be that you sort out this stuff in public to get the test cases done, and then it all goes behind closed doors and we never know the outcome.
Excellent. Well, plenty of work there for the lawyers, which is good news for those of us on the call. Thank you very much indeed for joining us today. And we very much look forward to hopefully welcoming you back next year when you might be able to give us a bit more info on those issues.
Something will have happened by this time next year, I'm sure.
Thank you.
Okay, thanks. Bye-bye.